This is Jason Wagner from the Wagner Oehler Law Firm. Today we're going to be talking about one of the risks to your estate is your own family in some cases. So when we're thinking about the different ways that an estate plan can go wrong or that we have unintended consequences in an estate, there's a few things. Well, there's always taxes. Did we properly anticipate and plan for estate taxes and other types of taxes? One of those could be, well, maybe we fall into state default rules because we didn't do our estate plan at all, and now we're subject to the state's estate plan. But a common one that I think needs to be addressed in every estate plan is the potential for family conflict. So, we think about estate planning and it's how to get your assets from you to your kids, right? That's often how people want to approach it. And by definition, we are moving wealth. Those assets have value. So by creating an estate plan, we are therefore moving and creating intergenerational wealth. And one of the biggest threats to intergenerational wealth is the family itself. In the event of a conflict and a dispute, whether that's because the estate plan wasn't crafted properly or because we just can't anticipate everything, that family conflict comes with a high cost. We've got attorney's fees, we've got time involved, potentially court costs, potentially delayed decision-making on estate taxes, which in some cases could cost us very valuable elections or deductions. So we've got now our family wealth being destroyed by the family because of this conflict, which I assume isn't the intent of anyone here. So, for example, we might have a client or someone that went through and has a will-based estate plan, which now means it's subject to probate. By definition, we have to give notice to all interested parties if it's in a probate. And an interested party is anyone that's an heir or a potential heir. That doesn't mean we only send notice to beneficiaries. We have to send notice to heirs, even if they're not a beneficiary. So now they're getting notice, they're pulled into this court process, and they're notified right away that they're entitled to notice, but they're not entitled to anything under the estate. Well, is that going to sit well with them? Are they going to raise any issues with that? We don't know. So that's a potential. They can object to the appointment of the personal representative. So now we don't even have the ability to act in the estate. They could object to how the accounting is done or how certain tax elections or deductions were done. Does the estate plan properly address that? Does it give the personal representative enough leeway and flexibility and discretion to take these actions without having to get it signed off on by every interested party in the estate? Maybe, but is that going to stop this person from objecting? Not always. So, it's important that we're thinking about that. Then we've got another situation, transfer on death deeds. Great tool in the right circumstance, but I don't like to use them when we have more than 3 or 4 beneficiaries. Personally, I would never leave a property to family on a transfer on death deed if we had 5 or 6. I've seen up to 7 individuals listed as beneficiaries on a transfer on death deed. Does it effectively transfer title after the death of the owner to the beneficiaries? Yes, it does. But what does that mean? Well, in Minnesota, in order to sell a property, you and your spouse all have to sign the deed. So now if we've got 7 individuals listed as beneficiaries on a transfer on death deed, do we have 7 individuals involved in the decision-making for the estate? No, we potentially have 14 individuals, all 7 plus their spouses. Can you get 14 people to agree on anything? It's difficult. It's definitely going to be time consuming. Did you save the probate? Yes. Did you save time? Probably not. Did you save expenses? Probably not, because the cost of pulling all those people together and the time of pulling all those people together is not insignificant. If everybody's getting along and everybody's living and nobody's in the middle of a divorce or anything like that, it makes it easy. But what happens if if they are in a difficult marital situation, or we've got somebody that doesn't quite agree with the decision of the rest of the group. Or what happens if one of those beneficiaries on that transfer on death deed dies before the owner? Now we have a probate for that person. So great tool in the right circumstance, but you have to be thinking about these things. Is your estate plan set up in the way that's best going to protect what you are trying to do, which is pass your assets from you to somebody else? So any good estate planning attorney should be anticipating and addressing these sources of potential conflict within the family. Even if you don't, that's their job. So, is this the right tool? Is a will the right thing to use? Is a transfer on death deed the right thing to use? Is a trust the right instrument to use? Those are all things they should be thinking about. We should be thinking about, well, if there's a distribution of a farm or a cabin and it's subject to a right of first refusal or a purchase option, how is that purchase price going to be established? Is it an appraisal? What happens if they disagree over who's going to appraise it? Who ultimately gets to make the decision? Who should act as trustee? If it's someone in the family, do we have an independent trustee named as a backup or a standby that can step in if they need to? Is our trustee the best person for that? Are they going to create more conflict? Is there a conflict resolution provision in the documents? I like to include those in all the trusts that we draft here. We have conflict resolution language. We like to include mediation clauses. Does your document have something that requires mediation rather than saying that they can go off to and have to go to court to dispute something? These are all things that should be part of the estate planning process, not necessarily something that you as a client should be coming up with on your own. This is something that any good estate planning attorney should be thinking about ahead of time, and should be applying to your situation to know where are the potential sources of conflict and where are those things that we don't know are sources of conflict, but we can still put something into our estate plan that's going to address it if something comes up in the future. So it's important to take all of these things into consideration. Remember that the biggest sources of potentially dragging down your estate and delaying administration, taxes, potentially no estate plan at all, and family conflict. So to learn more, you can check out the rest of our videos on YouTube, go to our Facebook page or wagnerlegalmn.com.